When Tom Hanks walked into the Supreme Court that morning, Chief Justice Roberts was confident he could quickly dismiss the actor's immigration arguments with superior legal knowledge. The respected jurist had no idea he was about to face someone who had quietly become one of the most knowledgeable immigration law scholars in America. What began as an attempt to put a celebrity in his place would end with Roberts learning constitutional lessons from Captain Miller himself. Before we dive into this extraordinary legal confrontation, make sure to subscribe to our channel and hit the notification bell so you never miss these incredible stories of hidden genius and unexpected triumph. The marble corridors of the Supreme Court building echoed with hushed conversations as Washington's legal elite gathered for what promised to be one of the most significant immigration cases in decades. Martinez versus Department of Homeland Security had attracted national attention not just for its potential to reshape American immigration policy, but because of an unexpected amicus brief filed by Hollywood icon Tom Hanks. Chief Justice John Roberts, now in his 20th year leading the nation's highest court, had built his reputation on intellectual rigor and judicial temperament. At 70, Roberts commanded respect from across the political spectrum for his careful legal reasoning and institutional leadership. He had presided over landmark cases involving healthcare, voting rights, and executive power, establishing himself as one of the most influential chief justices in modern history. The case before the court involved Maria Martinez, a refugee from El Salvador whose asylum application had been denied despite credible evidence of persecution. Lower courts had split on the interpretation of asylum law, creating the constitutional conflict that brought the case to the Supreme Court. What made this hearing unusual was that Tom Hanks had been granted the rare privilege of presenting oral arguments as a friend of the court. Hanks had arrived that morning looking characteristically understated in a charcoal gray suit, carrying a worn leather briefcase that had accompanied him to film sets around the world. At 67, America's most beloved actor maintained the everyman quality that had defined his career, but those who looked closely might have noticed the legal pad covered in precise handwriting and the stack of case law citations organized with meticulous care. The courtroom filled with an unusual mix of legal scholars, immigration advocates, and entertainment reporters drawn by the celebrity involvement. C-SPAN cameras prepared to broadcast what many expected would be a brief, symbolic appearance by a well-meaning but legally outmatched actor. Roberts called the court to order with his customary authority. We will hear argument first this morning in Case 23-1247, Martinez versus Department of Homeland Security. Mr. Hanks, as amicus curiae, you may proceed. Hanks approached the podium with the same quiet confidence he brought to his most challenging roles. Mr. Chief Justice, and may it please the court, I appear today to address fundamental constitutional questions about how we interpret asylum law in the context of credible fear determinations. His opening was professional but unremarkable. Roberts, who had reviewed Hanks's brief with skepticism, saw an opportunity to establish the proper boundaries between celebrity advocacy and serious legal discourse. Mr. Hanks, Roberts began, his tone politely dismissive. While the court appreciates your interest in immigration issues, these cases involve complex interpretations of federal statutes and constitutional law. Don't you think such matters are best left to legal experts rather than, well, actors? A murmur ran through the courtroom. Roberts's comment, while not openly hostile, carried an unmistakable condescension that suggested Hanks was out of his depth. The Chief Justice clearly expected the actor to defer to superior legal knowledge and wrap up his appearance quickly. Hanks paused, meeting Roberts's gaze directly. Those who knew him recognized the calm focus that preceded his most powerful performances. Mr. Chief Justice, I understand your concern about expertise. That's precisely why I've spent the last 8 years studying immigration law at Georgetown University Law Center, where I recently completed my Master of Laws degree with a concentration in constitutional immigration jurisprudence. The courtroom fell silent. Roberts's eyebrows rose slightly as he processed this unexpected revelation. Several justices leaned forward with newfound interest. Furthermore, Hanks continued, reaching into his briefcase, I've had the privilege of working closely with Professor Eleanor Martinez, no relation to the petitioner, who directed the Georgetown Immigration Law Clinic, and is widely regarded as the nation's leading expert on asylum jurisprudence. Hanks placed several documents on the podium. My analysis of this case is based not on celebrity opinion, but on constitutional scholarship and 8 years of studying how our immigration laws intersect with fundamental due process protections. The transformation in the courtroom was immediate. What had begun as an expected mismatch between judicial authority and Hollywood advocacy had suddenly become a serious legal dialogue. Roberts, clearly reassessing his approach, decided to test Hanks's claimed expertise. Mr. Hanks, the government argues that credible fear determinations are inherently subjective and therefore deserve substantial deference under Chevron. How would you respond to that position? It was a sophisticated question designed to probe whether Hanks truly understood administrative law doctrine. The Chevron deference test was a complex area of jurisprudence that separated legal novices from serious scholars. Mr. Chief Justice, I believe the government's reliance on Chevron is misplaced for several reasons, Hanks replied without hesitation. First, as this court held in King v. Burwell, Chevron deference doesn't apply when Congress has directly addressed the precise question at issue. The Immigration and Nationality Act specifically defines the credible fear standard in Section 235B, 1BV. Hanks turned to a specific page in his notes. Second, credible fear determinations involve mixed questions of law and fact that require constitutional analysis under the Due Process Clause of the Fifth Amendment. As the court established in INS v. Chutta, immigration proceedings must comply with constitutional requirements even when Congress delegates authority to administrative agencies. The legal precision of Hanks's response caught Roberts off guard. This wasn't a celebrity reading talking points. This was substantive constitutional analysis delivered with remarkable fluency. Justice Elena Kagan, clearly impressed, jumped in. Mr. Hanks, your brief makes an interesting argument about the intersection between asylum law and constitutional due process. Could you elaborate on how Matthews v. Eldridge applies to credible fear determinations? Hanks turned to address her directly. Justice Kagan, Matthews established the three-factor test for determining what process is constitutionally due in administrative proceedings. When we apply those factors to asylum cases, the constitutional requirements become clear. He held up 3 fingers, counting off each element. First, the private interest affected, the right to remain in the United States and avoid persecution, is fundamental. Second, the risk of erroneous deprivation under current procedures is substantial, given that credible fear interviews often occur without adequate preparation time or legal representation. Third, the government's interest in efficient immigration processing, while legitimate, cannot override constitutional due process requirements. Hanks paused, then delivered his most powerful point. The court's decision in Landon v. Plasencia makes clear that even non-citizens are entitled to due process protections when the government seeks to restrict their liberty or safety. Asylum seekers fleeing persecution have constitutional rights that cannot be dismissed through administrative convenience. Justice Samuel Alito, known for his conservative approach to immigration cases, entered the discussion. Mr. Hanks, that's an expansive reading of due process rights. How do you reconcile that with the plenary power doctrine that gives Congress broad authority over immigration? The question went to the heart of immigration law's most complex constitutional issues. The tension between congressional plenary power and individual due process rights had puzzled legal scholars for decades. Hanks's response demonstrated remarkable sophistication. Justice Alito, you're absolutely right that the plenary power doctrine gives Congress extensive immigration authority. However, as this court held in Zedvitas v. Davis, that power is not unlimited when constitutional rights are at stake. He opened another section of his materials. The key distinction is between Congress's power to establish immigration categories and procedures, which is indeed plenary, and the government's obligation to follow constitutional requirements when implementing those procedures. Due process doesn't limit who Congress can admit or exclude, but it does require fair procedures for making those determinations. Hanks continued with growing confidence. Moreover, the court's recent decision in Department of Homeland Security versus Thurosigium, while limiting some constitutional protections for border cases, specifically preserved due process rights for asylum seekers who demonstrate credible fear. We're not asking the court to expand constitutional protections. We're asking you to enforce protections that already exist. Chief Justice Roberts, who had entered the hearing confident of his legal superiority, found himself engaged in a sophisticated constitutional dialogue with someone he had initially dismissed. His tone became markedly more respectful. Mr. Hanks, your analysis of existing precedent is quite thorough, but the practical implications concern me. If we accept your constitutional framework, wouldn't that require fundamental changes to how the immigration system operates? Hanks nodded seriously. Mr. Chief Justice, constitutional requirements sometimes do require systemic changes. But I would argue that's not necessarily problematic if current procedures violate due process. He reached for a statistical analysis he had prepared. My research, conducted in partnership with the Georgetown Immigration Law Clinic, analyzed 2,847 credible fear determinations over a 3-year period. We found that asylum seekers with adequate preparation time and legal representation had credible fear approval rates 73% higher than those processed under current rush procedures. Hanks looked directly at Roberts. This isn't just about legal theory. It's about real people whose lives depend on whether our constitutional principles are applied consistently. The data shows that better procedures lead to more accurate decisions, which serves both humanitarian goals and the government's interest in effective immigration enforcement. Justice Sonia Sotomayor, who had been taking detailed notes throughout Hanks's presentation, spoke up. Mr. Hanks, your empirical analysis is compelling. Have you studied how other countries handle similar constitutional questions in their asylum systems? Yes, Justice Sotomayor. I've examined asylum procedures in 17 developed democracies as part of my graduate research. Hanks turned to another section of his materials. Countries like Canada, Australia, and the United Kingdom all provide more extensive procedural protections while maintaining effective immigration control. Their experience demonstrates that due process and administrative efficiency are not mutually exclusive. The courtroom atmosphere had completely transformed. Reporters were frantically taking notes, recognizing they were witnessing something unprecedented. The man known for playing Forrest Gump in Captain Miller was delivering a constitutional law seminar to the Supreme Court. Justice Brett Kavanaugh raised a practical concern. Mr. Hanks, assuming we accept your constitutional analysis, what specific remedies would you propose? How should lower courts implement enhanced due process protections? Hanks was ready with a detailed response. Justice Kavanaugh, I would propose a 3-part remedy framework based on existing constitutional requirements. He moved to address the full court. First, asylum seekers should receive adequate notice of credible fear standards and sufficient time to prepare their cases, a minimum of 10 days rather than the current practice of same-day interviews. Second, they should have access to legal representation or, at minimum, detailed information about their rights and the legal standards they must meet. Third, credible fear denials should include written explanations with specific findings, allowing for meaningful appellate review. Hanks paused, then continued. These requirements are modest compared to the due process protections this court has required in other contexts involving fundamental rights. They would improve decision-making accuracy while adding minimal administrative burden. Chief Justice Roberts, now fully engaged with the substance of Hanks's argument, posed a final challenge. Mr. Hanks, your proposed remedies sound reasonable in theory, but how do we know they would work in practice without overwhelming the immigration system? Because we can look at historical precedent, Mr. Chief Justice. Hanks's response revealed the depth of his research. Between 1996 and 2005, when immigration courts provided more extensive procedural protections, case processing times were actually shorter because fewer cases required appellate review. Better initial procedures reduced overall system inefficiency. He reached for his final document. Additionally, I've worked with immigration advocates to develop a pilot program proposal that could test these procedural improvements in select jurisdictions. This would allow empirical assessment of constitutional requirements without immediate nationwide implementation. The comprehensive nature of Hanks's preparation was remarkable. He hadn't just studied constitutional theory. He had developed practical solutions based on empirical research and comparative analysis. Justice Amy Coney Barrett, who had been quietly observing throughout, asked her first question. Mr. Hanks, your research methodology appears quite sophisticated for someone without formal legal training prior to your graduate work. How did you develop this analytical approach? Hanks's response revealed the personal motivation behind his legal studies. Justice Barrett, my interest in immigration law began 12 years ago when I was researching a film role about refugees. I met families whose experiences with our asylum system troubled me deeply, not because of the ultimate decisions, but because of the lack of fair procedures. His voice took on the sincerity that had made him America's most trusted actor. I realized that if I wanted to advocate effectively for procedural fairness, I needed to understand the constitutional principles at stake. That led me to enroll in evening law courses while continuing my acting career. Hanks continued. What started as preparation for advocacy became genuine fascination with constitutional law. I discovered that many of the narrative principles that make stories compelling, fairness, preparation, the importance of process, are also fundamental to our legal system. The personal dimension of Hanks's legal journey resonated throughout the courtroom. This wasn't celebrity grandstanding. It was a result of years of dedicated study motivated by genuine concern for constitutional principles that A.S. Hanks's allotted time neared its end. Chief Justice Roberts made an unusual decision. Mr. Hanks, the court will extend your time by 10 minutes. Your constitutional analysis raises important questions that deserve full exploration. The extension was virtually unprecedented for an amicus presenter and signaled Roberts's complete reversal from his initial dismissiveness. Hanks used the additional time to address broader constitutional themes. Mr. Chief Justice, this case ultimately asks whether our constitutional principles apply equally to all people within our borders, regardless of their citizenship status or the circumstances that brought them here. He looked around at all 9 justices. The Due Process Clause doesn't say no citizen shall be deprived of life, liberty, or property without due process of law. It says no person. That word choice was deliberate, reflecting the founders' understanding that constitutional protections must extend to all people subject to government power. Hanks's conclusion was both legally precise and morally compelling. When we deny fair procedures to asylum seekers, we don't just harm vulnerable individuals. We undermine the constitutional principles that protect all of us. The court has an opportunity to reaffirm that in America, due process is not a privilege for the powerful, but a right for everyone. As Hanks concluded his presentation and returned to his seat, the courtroom remained silent for several moments. The transformation from celebrity advocate to constitutional scholar had been complete and undeniable. Chief Justice Roberts, who had begun the hearing confident he could quickly dismiss Hanks's arguments, found himself addressing a final question to someone he now clearly respected as an intellectual peer. Mr. Hanks, do you have any final thoughts for the court's consideration? Hanks stood briefly. Only this, Mr. Chief Justice. The Constitution's promises mean nothing if we don't honor them when it's difficult. These asylum seekers don't ask for guaranteed outcomes, only for fair procedures that reflect our nation's highest legal principles. That's not too much to ask of the greatest legal system in the world. The hearing concluded with Chief Justice Roberts offering something rarely heard in Supreme Court proceedings. Mr. Hanks, your preparation and analysis have been exceptional. The court thanks you for your contribution to this important constitutional dialogue. As the justices filed out, legal observers struggled to process what they had witnessed. Tom Hanks hadn't just held his own against the Chief Justice. He had delivered one of the most compelling constitutional arguments many veteran court watchers could remember. The immediate aftermath was extraordinary. constitutional law professors began dissecting Hanks's arguments within hours, with many praising his sophisticated analysis of due process doctrine. Immigration advocates hailed his empirical research methodology, while conservative legal scholars acknowledged the rigor of his constitutional reasoning even when disagreeing with his conclusions. 3 months later, the Supreme Court issued a 7-2 decision in Martinez v. Department of Homeland Security that adopted many of the procedural protections Hanks had advocated. Chief Justice Roberts, writing for the majority, cited Hanks's amicus brief 4 times and incorporated his 3-factor remedy framework almost verbatim, an unusual footnote. Roberts wrote, "The court benefited substantially from a thorough constitutional analysis and empirical research provided by amicus curiae Thomas Hanks. His scholarship demonstrates that important legal insights can emerge from unexpected sources when combined with rigorous study and genuine commitment to constitutional principles." The decision transformed American immigration law, establishing new due process protections for asylum seekers while maintaining efficient administrative procedures. More importantly, it demonstrated that constitutional expertise could develop outside traditional legal institutions when driven by genuine commitment to justice. For Hanks personally, the Supreme Court appearance marked a new chapter in his already distinguished career. While he continued acting, he also began teaching immigration law as an adjunct professor at Georgetown, established a scholarship fund for aspiring immigration lawyers, and founded a legal clinic providing representation to asylum seekers. The confrontation between Chief Justice Roberts and Tom Hanks became a modern parable about the importance of preparation, the danger of assumptions, and the power of constitutional principles to unite people across different backgrounds and expertise. Interviews following the decision, Hanks remained characteristically humble about his transformation from actor to constitutional advocate. "The law belongs to all of us," he said. "When fundamental rights are at stake, every citizen has a responsibility to understand the constitutional principles that protect our democracy." Perhaps most remarkably, the case established a new model for celebrity advocacy, one based not on fame or emotional appeals, but on rigorous scholarship and constitutional expertise. Hanks had proven that with sufficient dedication and study, anyone could contribute meaningfully to America's ongoing constitutional dialogue. The man who had once portrayed a simple-minded character who stumbled into historical significance had become a real-life constitutional scholar who used careful preparation and legal expertise to advance fundamental rights. It was, as many observers noted, the most perfectly Tom Hanks story imaginable, an everyman hero who succeeded through hard work, preparation, and unwavering commitment to doing what was right.